I'm going to talk about how Reliance Insurance Company misapplies the pre-existing condition clauses in denying disability insurance claims. Now, I've given you a hint of that in my last piece, but I'm going to dig into some greater detail here for you. Now, if you have just signed up for your employer's disability insurance coverage, the question is going to be, when you file a claim, was whether you were getting medical treatment for the medical problem that you're now claiming that you are disabled from. And the disability insurance carrier is going to look at the pre-existing condition clause in their disability policy. The problem with this clause is that many disability policies have this pre-existing condition clause, and there are different versions of it. And even with different versions, carriers still make the mistake of misapplying the pre-existing condition clause. So for the sake of this discussion, we're going to talk about a common version of the pre-existing condition clause. So listen to this carefully. Benefits will not be paid for total disability that is caused by, contributed to by, or resulting from a pre-existing condition. That's pretty broad. Now, how is pre-existing defined? It's defined as any sickness or injury for which the insured received medical treatment, consultation, care, or services, including diagnostic procedures, or took prescribed drugs or medication during the 3 months immediately prior to the effective date of insurance. Now, that exclusionary language is very narrow, and the exclusion applies only if the disability results from or is caused or contributed to by a pre-existing condition. In other words, for the exclusion to apply, the carrier has to show that the insured's pre-existing condition has itself substantially caused or contributed to the disability. Courts across the country have held that to apply an exclusion for a disability that is caused or contributed to by a pre-existing condition, the carrier has to prove that the disability was substantially caused or contributed to by the pre-existing condition. You can tell from the tone of my voice that the operative term is substantial. A predisposition or stability to the injury isn't sufficient when the degree of relationship is undetermined. There has to be medical evidence of a significant magnitude of causation. So how does this work in the real world? Let me tell you a story that will give us some answers. Ms. Gustafson-Feiss was struck by a car in 2016. She broke several bones in her pelvis and her sacrum. She worked for Microsoft through various contractors, and she was required to do regular international travel and move heavy displays. As a result of her injury, she had multiple spinal and pelvic surgeries, and she underwent physical therapy. She was released to return to work without any restrictions and limitations in December of 2017. So she accepted a new position with another Microsoft contractor in February of 2018, and she signed up for that Reliance disability insurance policy through her new employer after completing the 30-day waiting period. The Reliance policy had a pre-existing condition clause that said, we won't pay for any disability where the insured has been treated in the 90-day period of time before coverage became effective. She had not gone or undergone any medical care during the 90-day look-back period, but she was tapering off of pain medication. Also, she had torn the labrum in her hip while on a work trip to China, and she applied for her Reliance disability benefits in August of 2018. So what did Reliance do? They were looking for coverage defenses. So they had a pre-existing condition review by its physicians. They, of course, concluded that she had previously injured her pelvis and had been treated for hip pain, and that this new injury was likely related to the 2016 accident. And they denied her claim under the pre-existing condition policy provision. Unfortunately, her condition worsened. Her surgeon insisted that her pain wasn't caused by the labral tear, but by the sacrum hardware. She had surgery to remove the hardware, and in turn, that destabilized her spine. Ms. Gustafson-Feiss had unhealed spinal fractures, and ultimately, she was left in a wheelchair. She was very unhappy, as we could understand. She found another doctor who confirmed that the labral tear was, in fact, the original source of her August 2018 pain, and that she had congenital issues that contributed to the tear. The congenital issues clearly were not caused by the 2016 accident. So she appealed the denial, and Reliance had another in-house liar-for-hire doctor who opined that the labral tear was presumably related to the 2016 accident, without commenting on the congenital nature of the tear. And of course, you know, this case ended up in federal court. As part of the judge's determination in this case, you need to understand that a court can interpret the terms of the policy and they're not bound by the carrier's interpretation. This is called the doctrine of contra pro forentum, and it allows the court to decide what the policy language says and how it's applied. So in this case, the judge determined that Reliance had failed to meet the Ninth Circuit law for applying the pre-existing condition limitation. In this case, was in the Ninth Circuit. Because the policy language required Reliance to prove that her 2018 injury was caused, contributed to, or the result of a pre-existing condition, the court said, look, that is pretty clear. The disability insurance carrier has got to prove that the pre-existing condition itself substantially caused or contributed to the disability. Now, Reliance's denial was based on the unsupported, unfounded conclusion that her disability was directly related to the 2016 accident, without any analysis, without any proof, and was contradicted by her treating physicians. The court said, oh, no. This unsupported conclusion doesn't meet its burden of proof that the accident was a substantial cause of Gustafson's Feist's 2018 disability. And the court overturned that denial. But you can see here that the decision turned on the policy language, the medical timeline, the opinions of the liar for hire doctors and her treating physicians, and the basis of these opinions. When you are applying for your disability insurance benefits, you're putting your medical, your financial, and your work status at issue. And disability carriers are always looking for a reason to deny the claim. The first line of defense is a coverage defense, and the pre-existing condition clause evaluation will always be done if you have just become eligible for and have signed up for your disability coverage and are claiming that you are disabled. So be prepared for that.